Hey everyone, Eric Rodebois. So we are testing out a new microphone and we're going to do a 5-minute video talking about ambiguities in contracts. Now, where I see this come up a lot is where you're raising money or there's a broker fee or some sort of commission. And so what'll end up happening is you'll have a written agreement most of the time. Hopefully in every story that I tell you, there's a written agreement. So actually, let me tell you the story. So gentleman is being hired to raise money for a fund. And so in his agreement, there is clearly set out that he's going to be a W-2 employee. He's going to get a salary. He's going to get benefits. He's going to get certain levels of bonuses. But then he's also going to be entitled to commissions based off of how much money he raises. And a lot of that, it comes down to the relationships, right? A lot of times it's like, well, I made the introduction to so-and-so. So all of this is good, and it's a pretty good contract, and everything's clear. However, and the however is now why we're making the video and why we're talking. So I asked the guy, what's going on? And he goes, well, I think they owe me a lot of money. We're in a big fight. I'm like, okay. And by the way, most of the time, people only come to me before the deal is done so that we can make a good contract, or they come to me after the deal's fallen apart and people are fighting over money. And so he says, well, here's the deal. So under the original contract, it's pretty clear that I was entitled to some basic things, but then I was also entitled to the commissions off of the relationships that I made to raise money for the fund. And what happened is the people that ran the fund came to me and we orally changed the contract. And I was like, well, was there anything else in writing? He goes, no. I'm like, how about emails? He goes, no, it was just an oral agreement. I'm like, okay, well, what's the basis of the agreement? The agreement was the percentages of what he would get would change, but he says it was percentage would change on any new relationships made going forward from the date of the oral agreement versus any of the previous relationships, which would be under the old agreement, right? So if I made an introduction to you under the old agreement and they ended up investing a lot of money, I got the old commission versus if I made an introduction after we made the old agreement. Now, let's pause real quick. Most contracts, most well-written contracts will have a very clear clause in there that says that you can't make changes or amendments or alter the terms of the agreement unless it's in writing, because of exactly what we're facing now, where it's he said, she said, you said this, no, I didn't. Well, I've got this text message. Well, I've got this email, or maybe I've got neither. And so in order to remove these ambiguities, what we do is we say, listen, if you're going to modify this agreement, it has to be in writing. So in this story, the more powerful party had lawyers. So you just call your lawyer and say, hey, lawyer, we're amending the contract. Can you either make a fully amended and restated agreement, which would fully alter the terms, even if it's just primarily focusing on a couple key points? Or is it going to be a really short amendment where we just amend section 3 and we make the new schedule? And so where we are now is under a very conservative reading of this contract, which is against my client, he's probably owed about $100,000. And under a very aggressive and favorable reading of the contract that is favorable to my client, he's owed $1.7 million. So that delta, the 1.6 million, is what we're going to end up fighting about. And if I could go back in time, I would say, listen, if you're going to make any modifications, get it in writing. And so my guy says, wait a minute. It was clear that the old relationships, I was going to get to keep them at the old commission rate. And on top of that, let's say I made an old introduction, but then that old introduction itself made another introduction. Who owns that relationship? And he's like, I should own that relationship. I'm like, well, was that clearly spelled out in the contract? He goes, no, we didn't think about it. And so this is where contract lawyers, this is where litigators, this is where we make all of our money. It's when people have disagreements about money and we're fighting about interpretations and things like percentages and relationships. Now, this will come up a lot in broker contracts. We see it all the time where somebody wants some sort of fee or bonus for making introductions. Now, I will just say that we need to be careful there because different states actually have different laws, and there's actually the SEC which gets involved depending on the circumstances for when we're giving commissions to either, like, for example, here in Florida, you can't get a commission on a real estate transaction unless you have a real estate license. And so people will kind of do the back of the envelope, oh, well, I made the introduction. And a lot of times they'll be making the introductions before they even have a contract. And so this is where, you know, unfortunately over the last number of years, we've had to litigate a number of these cases. So if I can leave you with anything, first of all, always have a good contract, always have something in writing. But then second of all, when you make changes to that contract, make sure you do that in writing, and then always try to think 1 or 2 steps ahead. So my guy was like, what about the relationship after the relationship after the relationship? I'm like, well, maybe we should have written that down. So if you have any questions about any of this, leave a comment and hopefully I can help you work through these situations. Thanks.